All rise. For the 5th District, State of Florida is now in session. Now, Richard B. Orfinger, Judge, all presenting business for this court, Your Honor, you give attention and you shall be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal said, I'm Judge Orfinger, and I'm joined on the panel today by Judge Torpy, to my right, your left, and Judge Cohen, on my left, your right. We have 5 cases this morning. The Mucha versus Atlas is an add-on, which we moved from yesterday, and that'll be the last case. We're going to take them in the order. I do have a question. If the parties in Whitman and Whitman are here, we received a motion to dismiss the child. Are the attorneys here on that case yet?
Yes, Your Honor.
We received a motion late yesterday to dismiss the child based upon the mediated settlement. Is there any objection to that?
Your Honor, I filed that motion. Lisa March on behalf of the minor child, Rachel Whitman. I don't know if Ms. Janusa objects.
Well, we don't really see it being an issue for argument for the other issues because there was 2 parties in regards to our briefs. So respectfully, we don't have issue with that. But for purposes of argument, then I'll be arguing just solely on behalf in regards to the wife. And the
Okay, fair enough. And we'll go ahead and dismiss the child as a party to that action based on the settlement. And you're welcome to stay or go as you deem appropriate.
Yes, sir. Thank you, Your Honor.
All right, if you have a cell phone or pager, we'd appreciate it if you would turn it off so that the attorneys aren't interrupted during their arguments. We start the docket this morning with 2 criminal cases, so the parties will have 15 minutes per side, and if the appellant will let me know if he or she wants to reserve some time, I'll be happy to try to indicate that on the timer and by signal. So with that, we'll go ahead and call the first case this morning, Joseph HABIB versus State of Florida.
May it please the court?
Good morning, sir.
My name is Robert Yates. I represent the appellant Joseph HABIB. I'd like to reserve 5 minutes for purposes of rebuttal, Your Honor.
Certainly.
This case had a somewhat of a large record, but the issue before the court today is surrounding a suppression issue and a confession of a criminal case that originally started out as a lewd and lascivious molestation case on a child under 12. The suppression issues are simply that when taken as a totality of the circumstances, if you look at everything that occurred within the police tactics and the questioning and what occurred, that under the totality of the circumstances that the confession should have been suppressed. And it's threefold.
What is our standard of review on this issue?
It's de novo, Your Honor. And I believe that if we look at the order that denied the actual motion to suppress, that the judge really skirted around the issue, which I felt was one of the more important issues in the case, was the officer's intention or tactics that were utilized to calculated to delude the suspect as to his true circumstances. If you look at the suppression order, the judge really touched on a Miranda issue that was brought up and some promises that were made to the suspect. The issue about calculation, the tactics that were used to delude the suspect as to his true circumstances really wasn't touched on in the actual suppression order. I know it was argued in front of the trial judge, but her order did not necessarily reference that issue. Taking the confession as a whole, we start out with the situation where we have these 2 officers from the Orange County Sheriff's Office that go down to Fort Lauderdale. They go to the fire station where the appellant is employed. He's sleeping. They have his boss wake him up. They take him to a room that has a glass window and full view of all his comrades and fellow employees. There's 3 armed Broward Sheriff's Office deputies out there. They're wearing their sex crime shirts and their weapons, and they pull him into this 10-by-10 room and they start questioning him about this incident. They introduce themselves. They tell him that they're there for the sex crimes unit, that their job is instilled by them from the sheriff to clean up the streets, that they have the responsibility to make sure that monsters aren't running around terrorizing people. That's how the questioning starts. From that point on, what we have is essentially everything, almost everything, in my opinion, if you look through the statement, is misleading or false. These officers tell him everything about what they supposedly did in the investigation. They've talked to all these children. They know they're telling the truth.
You know that certainly the fact that a police officer might represent facts that aren't true isn't going to be a basis for suppression of it.
And I understand that, Your Honor. I understand that the police officers are certainly allowed to use some misrepresentations in their interrogation process. If the issue were solely related to that, I would agree with Your Honor. But the issue is, I'm throwing, because the standard is the totality of the circumstances must indicate that such a confession is a result of a free and rational choice. That's just one component.
All right, so is the minimization, as you've articulated in your brief, more problematic for you? Is that what you're suggesting?
The couple of things, the deception is one thing. Clearly, in my opinion, if we read through that, everything that they said almost they didn't do or was a misrepresentation of what they did in their investigation. But then we have the fact that we have promises to get him help, indicating they want to get him help, in conjunction with the minimalization techniques. And this is a term that they've named it. This isn't something that occurred by, it just sort of happened and it was an afterthought, but this was actually a technique that they discuss. It's a technique. It's a minimalization technique. And
What's wrong with that?
well, it deludes the suspect into his true circumstances. And so they set it up with telling him that our job...
I mean, what's wrong with that? I mean, it's a tactic, right? It's a strategy to try to minimize create an impression in the defendant's mind that what he did or what they suspect him of doing is not, all that bad, so that he feels comfortable confessing to it. What's wrong with that?
Well, it minimalizes...
This is kind of a rough and tumble process, isn't it? I mean, in other words, the cops use tactics, they use strategies in order to elicit a confession. The question really is where is the line, and how do they cross it? And I guess that's really what I'm looking for you to tell me.
The line that I feel, Your Honor, is that when you have this minimalization technique, which the officers admit, it's a trick, it's a deception measure. When you have that and you
is that prohibited? Are the officers prohibited from using this minimization technique? And if so, what's your authority on that?
Well, the cases that my best cases, to put it frankly, Your Honor, that I'm relying on are Brewer versus State.
Do you have a best case, or do I have to read 10 of them in order to appreciate your position?
Well, the two cases that I feel that are important, Your Honor, are both Florida Supreme Court cases. Brewer versus State, which was a 1980 case that dealt with a murder case.
In Brewer, in that case, they start out by telling the guy, well, you're looking at the electric chair, and they tell him or imply to the defendant in that case that they had the authority to effect some sort of leniency. You don't think that that's distinguishable from the circumstances in this case?
Not really, Your Honor. Brewer and the Florida Supreme Court has said that implied or express promises are not favored. And in fact, the other case I was relying on, Bryant versus State, which is a 2005 Florida Supreme Court case, reiterated that. It's well established. So in this particular case, we have the Jessica Lunsford reference. They inject this into the interrogation. Now, at the time, the Jessica Lunsford case was a huge media event, and people were screaming for the death penalty and all kinds of things related to the individual that was arrested.
Well, they were telling him that his situation what he allegedly did was not nearly as serious as what happened in Jessica Lunsford. Isn't that what they were telling him?
What they said was, they said, listen, we understand that there are people who should be locked away for life, and then there's people on the low end of the totem pole who, in my opinion, need some counseling, need some help, made a mistake. So what he's trying to do is essentially minimize the situation as to, first of all,
what they said was accurate. I mean, when you compare the Lunsford case to this case on the overall spectrum, it pales in comparison, does it not?
It pales in comparison in the sense of what actually occurred to the victim in that particular case, and I agree with that. However, the fact that he equated, or this officer equated him to distinguish himself from a particular type of sex offender, I felt was the coercion, if you will, that actually was improper. I mean, he is left here in the totality of the circumstances to make a free and rational choice to talk to these officers.
Mr. Yates, in this case, we have a non-custodial interrogation, and yet the officers Mirandized him, and he apparently understood his constitutional rights. To what extent, if any, does the fact that even though they weren't required to Mirandize him, they did, and he understood that he had a right to a lawyer, understood that he could stop talking whenever he chose to, does that ameliorate any of the concerns that you have about this minimalization, assuming that minimalizing the conduct is a problem at all? If he understood that he wasn't required to speak at all, and that if he chose to, it had to be voluntary and he could talk to a lawyer at any time, how does that ameliorate that, if at all?
Well, Your Honor, that's an interesting question, because one of the issues in the original suppression motion was, in fact, the Miranda. Now, what the trial judge ultimately found was that Mr. Habib, who testified during the hearing that he, in fact, did ask for a union representative and an attorney, she felt that she made a credibility decision. Detective Kraubitz said, no, he didn't. Habib said, yes, I did. She made a credibility decision, and there's really no basis for me to argue.
Well, I mean, clearly that horse is out of the barn. So now, if we accept that finding as accurate, that he never requested counsel, to what extent, if any, do you think that would ameliorate your concerns about the interrogation techniques used by the officers? And you're down to about 4.5 minutes.
Real simply, Your Honor, I feel that if we look at what Brewer was set forth in comparison to what Bryant versus State reiterated, that the totality of the circumstances makes it that this gentleman did not have a free and rational choice. If you look at the promises that were made, the delusion as to his true circumstances, these guys knew that he was facing 25 years to life times 4. Yet they minimalized that. They were not honest with him as to what his true circumstances were. They used the fact that he was being interrogated in front of his co-workers. They used the fact that they were going to help potentially with the case or with counseling or with his family. And when you take all of that into consideration of the totality of the circumstances, he was woken up in the middle of his sleep, and he was brought into a room.
Well, I guess I would wonder if, irrespective of what the officers were thinking, did they really minimize it? I mean, he went to trial and he was convicted of 3 misdemeanors, which seems somewhat consistent with what they were saying. It's not right, but it's not that big of a deal.
Well, Your Honor, I don't think
they may not have intended to accurately convey his situation, but in hindsight, they really did.
My feeling on the jury verdict was that essentially the confession or the statement, if you will, was a tiebreaker in a case that really didn't have any physical evidence, no other evidence.
Well, but let me speak about that a bit, because I wanted to, before you sat down, to have you address harmless error. There were a number of witnesses other than, the victims, and while they might not have understood immediately what was going on, as they had an opportunity to reflect upon it, apparently they it got clarified in their minds what occurred. So you had a number of witnesses that, because this was a public pool, why, if there was error in the admission of the confession, would it not be harmless error?
The standard, whether or not there was a reasonable possibility that it contributed to the verdict. So if we look at there was no physical evidence, there's no videos, no pictures. It's strictly just witness testimony. There was 3 families involved. Only really one family provided some testimony as to what happened besides the actual children, which our position in the brief is laid out was that this really started with a situation where Mrs. Hawkins watched her children in front of the pool. The Savallo families were watching their children in very close proximity, sometimes between 4 feet, 10 and 15 feet. Miss Hawkins was talking to her babysitter and essentially believed that she saw something, wasn't sure what she believed. She pulled her son out of the pool and she said, I saw what happened to you, tell me what happened to you. And so our position that's laid out in the brief, Your Honor, was that really it was suggestivity. The children never got out of the pool. They never ran to their parents. They never stopped playing. They were never having a good time. But it was Miss Hawkins that pulled her son out of the pool and started that.
And coincidentally, your client in the confession acknowledged that you're saying it was suggested to the children, but your client actually verified that what they saw did in fact occur.
My client initially denied doing anything improper. It was only until the point where the minimalization, the Jessica Lunsford, and all those things.
But you're suggesting that the parents suggested to the children that this occurred, and there is other evidence in this record to suggest otherwise.
The evidence there's evidence that the children themselves testified, and I understand that. There's evidence really from the Hawkins family, the mother, the father. But if you look at the circumstances, they went, they ordered some drinks, they came back, they went into the hot tub, they came back. Miss Hawkins starts talking to the other parents. Then all of a sudden, everybody starts stirring, but none of the other parents who were watching their children saw anything.
All right, counsel, you've exhausted your time. I'll give you an extra minute for rebuttal.
May it please the court, counsel, good morning. My name is Kelly Neal, and I'm here on behalf of the state of Florida. It's the state's position that under the totality of the circumstances that this confession was voluntarily given. I would just like to point out a couple additional things. This was a 30-minute interrogation. It's not one of these situations where they were browbeating this man for several hours into confessing. The judge found that there were no promises and no misrepresentations. That was the last question that Mr. Habib was asked in the interrogation. Did we promise you anything? Did we coerce you? And he said no. So I think that's the best evidence that he did not feel coerced in this situation. If this court, I'd be happy to answer any questions if this court has any, but if not, I'll just rely on my brief then. Thank you. I'd ask this court to affirm the judgment and sentence of the trial court.
Maybe she could sell you her remaining time. We'll give you another minute.
Thank you, Your Honor. Referring back to the harmless error test, the Miss Hawkins was the one that essentially there were some bizarre circumstances about them getting drinks, coming back, not pulling their children out of the pool. She apparently said she saw this, but she watched her child for a long time. Everything that occurred was underneath the water. There's evidence the water was wavy. There was a lot of contradictory evidence in this particular case, and our position was that because there was this confession that occurred only after all of these tactics were utilized, that became the tiebreaker in the case, so that there was a reasonable possibility that it did contribute to the essential verdict in the case. Thank you. If there's any more questions.
Thank you, counsel.